Good afternoon and welcome to this webinar on what is GDPR and how will it affect you, delivered by the ISM Trust.
Before we begin, just a few technical points for you. You can't see me, but you should be able to see the PowerPoint presentation. The webinar is being recorded and will be available to view on the ISM's website at ism.org/webinars. For those of you who maybe don't know us, the Incorporated Society of Musicians, or the ISM as we're known, was established in 1882 to promote the art of music and to support professional musicians. Now, 13 years later, we support a membership of more than 8,000 music professionals of all kinds, teachers, performers, composers, and many more besides, with legal advice and representation, tax and business advice, and award-winning professional development opportunities, along with campaigning and advocacy for the music sector as a whole. Through our sister charity, the ISM Trust, we have established a means to share our experience and expertise with musicians beyond just those who are ISM members. And this webinar is part of the Trust professional development opportunities, open to all musicians. I hope you will find the information helpful. It will be available on our website at ism.org shortly after this webinar. Right, just looking at the next slide now. What you're going to learn today. So by the end of this webinar, you will have a clear picture of what the GDPR is all about. I will talk you through some key definitions which will help you ascertain whether the rules apply to you. If the rules do apply, I will discuss the 7 data protection principles and your obligations arising from these principles. In particular, what documents and policies you should put in place to ensure compliance with the rules. I will then talk to you about the various rights that individuals have and tell you about the Information Commissioner, who is the UK regulator in the area. Right, so turning to the law in this area. The UK is revising its data protection laws to comply with what is called the General Data Protection Regulation. And through this webinar, I will refer to this as the GDPR. This is an EU regulation that comes into force on the 25th of May 2018. Whilst we are to leave the EU, this will not affect the need to comply with the GDPR, as the UK will replace the current rules, which are contained in the Data Protection Act 1998, with new legislation that mirrors the GDPR, and it is currently doing this in the Data Protection Bill. The central objectives of the reform in this area are to make our data protection laws fit for the digital age and to empower people to take control of their personal data. This means that anyone who holds personal information about individuals must understand the law and what it requires of them. Essentially, the data protection laws regulate the use of information about living individuals, which is held in either an electronic format and/or, in some cases, on paper, where this is held in a filing system that is accessible according to specific criteria. I want to emphasise that if you hold information about living individuals in one or both of these ways, the data protection laws will apply to you. This may, for example, include information such as names, addresses, dates of birth, opinions about an individual, or any other information from which an individual can be identified. This may be your clients, students, their parents, and/or the names of individual contacts at organisations with whom you work. The data protection legislation provides a framework for the processing of personal data by data controllers. Now, these terms, that is, processing personal data and data controllers, have specific meanings which determine whether the data protection laws apply to you. I will, during this webinar, explain each of these terms. In the UK, the Information Commissioner will continue as the independent authority that upholds information rights and data privacy. During this webinar, I will refer to the Information Commissioner as the ICO. Right, turning now to some of those key definitions in the legislation. Do you process personal data? As I say, these definitions will help you to decide whether the rules apply to you. So it's important that you understand them. Firstly, looking at processing. This is widely defined and includes almost anything you can do with data, including obtaining, recording, holding, organizing, adapting, altering, retrieving, consulting, disclosing, combining, deleting, and/or destroying the data. The ICO states that it is difficult to imagine anything you could do with the data which is not processing. Secondly, what is personal data? This is information relating to an identified or identifiable living individual, and which is processed or to be processed by automated means. So for example, a computer, a smartphone, or a credit card machine, or data which forms part of a relevant filing system or is intended to form part of a filing system. Now, a filing system means any structured set of personal data which is accessible according to specific criteria. So personal data is likely to include customer and client lists, individual contact details, and HR records, for example. It also encompasses any expression of opinion or intentions in respect of an individual. And under the GDPR, online identifiers such as IP addresses will also constitute personal data. Another area to be aware of is what is called a special category of data. Stricter rules apply to certain categories of personal data, and as I say, they are called special categories of data. These used to be called sensitive personal data. It includes information about racial or ethnic origins, political opinions, religious beliefs or philosophical beliefs, trade union membership, health and sex life and sexual orientation. Now, if you process personal data and/or a special category of data, the rules will apply to you. Looking at some more key definitions, we are now going to look at who has rights and obligations. Now, the definitions for this category are data subjects, data controllers, and data processors. Let's start with data controllers. A data controller is the person or organization that controls the personal data, i.e., it will determine the purposes for which and the manner in which any personal data are or are to be processed. Data controllers will usually be organizations, but can be individuals who, for example, work on a self-employed basis. So if you control personal data, you will be the data controller. Now, data subjects, that is the identified or identifiable living individual who is the subject of the personal data. During this webinar, I will also refer to the data subject as the individual. Finally, data processors. This is any person who processes the data on behalf of a data controller. So, for example, if you, a data controller, send any personal data to your accountant, the accountant would be a data processor. Please note that where you use a data processor, you must have a written contract in place which includes specific terms which deal with data protection. Where this applies to you, I recommend looking at the ICO guidance for the relevant terms that must be contained within your contract with any data processors. Right, so I just want to summarize where we are now. You are a data controller and you must comply with the data protection laws if you process the personal data of living individuals and you hold that data electronically or in a manual filing system. So some examples include if you're a private teacher that retains the personal details, for example, names, addresses, emails, bank details of parents and/or pupils for recording, accounting and/or invoicing purposes. Also, performers who keep records of their client details, ISM local group ambassadors who retain personal details of other ISM members, and perhaps choir leaders that retain personal details of choir members. So hopefully you now have a view on whether you are a data controller, and if so, the next question is, what does this require you to do? Well, there are three key aspects to this. Firstly, you must comply with what are called the data protection principles, and there are 7 of these principles. You must afford data subjects or their individual rights. And thirdly, if you are required to do so, you must notify the Information Commissioner, the ICO, that you are a data controller. I will tell you later on how to ascertain whether you need to do this, so don't worry about it for now. Okay, so we'll look at number 1, which is you need to comply with the 7 data protection principles. So when you process personal data, you must process them in accordance with these 7 principles. And I'm going to talk to you a little bit about each one of these principles. Number 1 requires fair, lawful and transparent processing. So personal data must be processed lawfully, fairly and in a transparent manner. I'm going to spend quite a bit of time now discussing this first principle because there's quite a lot to it. It requires you to tell people what you do with their information and to make sure you have a lawful reason for your processing activities. You should do this in a privacy policy or in a fair processing notice. So there are 2 main facets to this first principle, namely 1, fairness and transparency, which requires you to communicate privacy information in a privacy policy or notice. And number 2, lawfulness, which requires you to identify your legal basis for processing data and set this information out in that privacy policy or notice. So let's look at the first facet, that is fairness and transparency. So individuals should be provided with certain information, and this must be provided at the time their personal data are obtained. So that's an important point to note. That's the point at which you must notify individuals of your privacy information. This information, as I say, is most commonly provided in a privacy policy or notice, and the GDPR sets out the information you should supply in that policy or notice. This information is as follows, and you can find all this information on the ICO website. It includes your identity and contact details as controller. You must set out what personal data are collected, for example, names, addresses, telephone numbers, bank details. You must set out how personal data are collected from the individual and/or from other sources. You must set out the purpose of your processing, that is, what do you do with the data? For example, do you use it to administer your services, to process orders and payments, and to also communicate with them about these issues? You must set out the legal basis for the processing. So this requires you to ensure your processing is lawful under this first principle. I will shortly discuss the 6 legal conditions for processing which you must identify in order to process personal data. You must set out in your policy how individuals can manage their preferences and the right to withdraw consent at any time. For example, you must set out how individuals can tell you they no longer wish to receive communications from you. You must also include whether you share the personal data with anybody, any third parties, for example, schools or colleges, whether you transfer that data outside the EEA, and also your retention periods or criteria. So essentially set out how long you'll hold their details before you securely delete them. You must set out the existence of the data subject's individual rights, and again I'm going to shortly go on to discuss those individual rights for you. Your policy must state the rights of the individual to lodge a complaint with the ICO, whether the provision of personal data is part of a statutory or contractual requirement or obligation, and the possible consequences of failing to provide the personal data. And finally, you must set out in your policy any information about any automated decision making. That is, if any decisions are taken without human intervention. The information in your privacy policy or notice must be provided concisely, transparently, and in an intelligible form. It must also be easily accessible. So essentially, you must look at what personal data you hold, how it is obtained, what you do with it, and communicate this clearly to individuals at the time you collect their information. There is no one-size-fits-all answer here, as every business will need to consider its own particular circumstances. For guidance, I recommend you look to the ICO website, as it contains a guide to the GDPR and also contains specific guidance on privacy notices. So you'll recall that I'm explaining the first data principle, and we just covered the first part of that principle, which requires fair and transparent processing. The second part of this first principle requires that personal data is processed lawfully. And as I mentioned, there are 6 conditions on which you can rely to show that your processing is lawful. And once you've identified one or more of these conditions, you must include it in the privacy policy we've just discussed. Right, so of those 6 conditions, firstly, there's consent. So this is where an individual is given consent to the processing of his or her personal data for one or more specific purposes. However, to rely upon consent, you must ensure that the consent meets the high standard required by the GDPR. This requires offering individuals genuine choice and control. Specifically, it requires that consent must be freely given, specific, informed, and an unambiguous indication of the individual's wishes. What will not be acceptable under the GDPR is taking silence as consent, using pre-tick boxes, or relying on inactivity. It must also be as easy to withdraw consent as it was to give it. If you rely on consent, you must keep records of consent, showing how and when consent was given, and also you should record what privacy policy you issued at the time consent was given. Because of the high threshold required for consent, this may not be the ideal ground upon which to rely if you have another ground upon which or which does apply for you. So we'll go on to look at the other conditions now. The second condition for lawful processing is the performance of a contract. That is, the processing, so that your use of the data is necessary for the performance of a contract to which the individual is a party, or in order to take steps at the request of the individual prior to entering into a contract. So, for example, you can rely on this condition if you have to retain personal data for the purposes of invoicing for your services. The third condition for lawful processing is compliance with a legal obligation. This is where processing is necessary for compliance with a legal obligation to which you, the data controller, is subject. Obvious examples include if you employ someone, you will need to process their personal data to comply with the tax rules. Fourthly, there is vital interests. That is, you can process personal data where it is necessary in order to protect the vital interests of the individual or of another natural person. This is less likely to be relied upon, but could apply, for example, if you have to report a safeguarding concern. The fifth condition is public interest. That is, the processing is necessary for the performance of a task carried out in the public interest, or in the exercise of official authority vested in the controller. This is unlikely to apply to you and more relevant to public bodies. And the sixth and final condition which could apply is legitimate interests. That is, that the processing is necessary for the purpose of a legitimate interest pursued by, for example, you, the data controller, or by a third party, except where such interests are overridden by the interests, rights, or freedoms of the individual. So there are three elements to the legitimate interest condition which you should consider and document before relying on it. One is you must identify your legitimate interests for processing the data. Then you must consider whether the processing is necessary to achieve that interest. And then you must balance your interests against the individual's interests, rights and freedoms. As I say, if you rely on legitimate interests for your processing of personal data, you should document the assessment undertaken of why the processing is necessary to achieve this legitimate interest, and that you have balanced your interests against the individual's interests. An example of a legitimate interest could be using the data to develop and enhance your products or services. Finally, please note that there is a prohibition on the use of special categories of data. You'll recall this includes information about racial and ethnic origins, political opinions, religious beliefs, etc., except in very limited circumstances, which include where the individual has provided explicit consent to the processing for one or more purposes. You need to process that data to carry out the obligations under employment law, and where you need to process the data to establish, exercise, or defend legal claims. So one particular area which may be relevant to you and which is beyond the scope of today's talk is marketing. There is separate legislation about electronic marketing, that is marketing by email, text message, and automated telephone call, where in general you must have consent to contact individuals by those methods. It is subject to an exception, but if you engage in electronic marketing, then I do recommend you look at the ICO website for guidance on this, or that you contact the legal team here at the ISM if you're a member. So that was the first principle. In summary, it requires you to provide privacy information to individuals at the point at which you collect their personal data, and that this information sets out which conditions for processing apply. And as I say, of the 6 conditions, consent, performance of a contract, and legitimate interests are likely to be the most relevant to you. Now let's look at the other 6 data protection principles, which you can see on the slide. Number 2 is purpose limitation. That is, personal data must be collected only for specified, explicit, and lawful purposes, and not processed for any incompatible purposes, i.e., only process personal data for the purposes you communicated in your privacy information. If your purposes change, you must update your privacy policy and notify individuals of these changes. Principle number 3, data minimization. Personal data must be adequate, relevant, and limited to what is necessary for the purposes for which it is processed. So you should consider what information you need at the outset and collect and retain no more than is required. Principle number 4 is accuracy. You must keep personal data accurate and, where necessary, up to date. Inaccurate data must be erased or rectified without delay. Principle number 5 is storage limitation. Personal data must be kept in a form which permits identification of individuals for no longer than necessary. Principle number 6 is integrity and confidentiality. Personal data must be processed in an appropriately secure manner, including protection against unauthorized or unlawful processing, accidental loss or destruction, or damage by the use of appropriate technical or organizational measures. So, for example, you should ensure you have appropriate IT security for your systems, or, for example, that your paper files are adequately secured. Number 7, accountability. You are responsible as a data controller for demonstrating compliance with these principles by, for example, implementing policies, undertaking audits, and maintaining the necessary records. You should also consider and document measures taken to ensure you comply with these data protection principles. So these are the 7 data protection principles. Now let's talk about the individual rights I mentioned earlier. So under the GDPR, individuals will have a number of additional rights, which, as I stated earlier, also need to be communicated in your privacy policy. These rights are as follows. They have the right to be informed. This encompasses the obligation to provide fair processing information and in your privacy policy, which we've already discussed. Number 2 is the right of access. Individuals have the right to obtain confirmation that their data is being processed, access to a copy of their personal data, and other information which largely corresponds to the information in your privacy notice. This is called subject access. Under the GDPR, you will not be able to charge a fee for this. This is subject to limited exceptions. And a request from an individual for subject access must be dealt with within 1 month of receipt. However, it can be extended to 2 months where it's a complex case or there are numerous requests from the individual. Thirdly, individuals have the right to rectification. So personal data must be rectified where it is inaccurate or incomplete. And if you receive a request for this, you must respond again within 1 month. Again, this could be subject to extension to 2 months, by 2 months for complex requests. Then we have the right to object. So an individual can object to processing where it's based on legitimate interests. They can object to direct marketing, and they can object to processing for scientific or historical research purposes. On receipt of an objection, the data controller must stop the processing. There is the right to restrict processing of personal data. Where this right is invoked, the data controller can only store the data, but not further process it. This right applies in certain circumstances, including until any issues regarding its accuracy are resolved, where the individual has objected to processing and the data controller is considering whether its legitimate interests override those of the individual, where the processing is unlawful, if the individual requests restriction over erasure, and if the data is no longer required but the individual requires its retention for legal purposes. Then there is the right to erasure, or also called the right to be forgotten. This right enables an individual to request the deletion or removal of personal data where there is no compelling reason for its continued processing. This is not an absolute right and applies in certain circumstances, including where the data is no longer necessary for the purpose for which it was originally collected or processed. It also applies where the individual withdraws consent or where the individual objects and there is no overriding legitimate interest for continuing the processing. The right also exists where the data was unlawfully processed or to comply with a legal obligation. So, the next right is rights on automated decision making and profiling. Individuals have the right not to be subject to a decision when it is based on automated processing and where this has a legal effect or a similarly significant effect on the individual. Where this is the case, individuals must be able to obtain human intervention, express their point of view, and obtain an explanation to challenge it. There are exceptions to this right, including if the decision is necessary for entering into or performing a contract with the individual, or where based on explicit consent. So finally, the final individual right is the right to data portability. This right allows individuals to obtain their personal data from the data controller and reuse it for their own purposes across different services. This right is limited, however, to when processing is carried out by automated means. But where it does apply, the data must be provided within 1 month, again subject to that 2-month extension for complex requests. Right, moving on to talk about the Information Commissioner. There may be a requirement to register with the Information Commissioner. The current Data Protection Act requires the Information Commissioner to maintain a register of certain data controllers and the purposes for which they process personal information. This requirement to register will continue once the Data Protection Bill becomes law. If you hold and process information about individuals who are customers, employees, suppliers, clients, or other members of the public, you may need to record that on the register. This is called a notification. The best way to ascertain if you are required to register is to undertake the online self-assessment, and the website page address is on the slide for you. If you are required to register, there is a standard fee of £35 a year for notification. A failure to notify is a criminal offence. So, as I said, these slides will be available after the presentation, and you can pick off the website address from there. Moving on to breach notification and communication. So one aspect it is important you are aware of is breach notification and communication, because you may have to make a notification to the ICO. This is where a data breach is likely to result in a risk to the rights and freedoms of data subjects. This will be the case where the breach could have significant detrimental effect on individuals. So, for example, if it could result in discrimination, damage to reputation, financial loss, loss of confidentiality, or any other significant economic or social disadvantage. Examples of personal data breaches include the destruction, loss, alteration, unauthorized disclosure of, or access to personal data. Where a notification to the ICO is required, it must be made not later than 72 hours after having become aware of the data breach. Individuals must also be informed of the data breach without undue delay where there is a high risk to their rights or freedoms. Turning now to the penalties for failing to comply with the data protection laws. So the ICO has a range of investigative and corrective authorization and advisory powers to address infringements of the data protection laws. It can also impose fines for breach, and the level of these fines can be significant. The Data Protection Bill will enact additional powers for the ICO. It will allow the ICO to levy higher administrative fines, and for the most serious breaches, this can be up to £17 million or 4% of global turnover. Okay, so what to do now to prepare for the GDPR? We're almost at the end of this webinar, but I want to cover what you should do now to ensure compliance with the GDPR once it becomes law on the 25th of May this year. The ICO has produced a 12-step checklist you can take now to prepare for the GDPR, and this is available on its website. But the steps include a personal data audit. This includes two elements. Firstly, document what personal data you hold, where it came from, what you do with it, and who you share it with. Number two, identify your lawful basis for processing personal data and document this. You'll recall that I said consent, legitimate interests, and performance of the contract are likely to be the most relevant to you. Where you do rely on consent, you should review how you seek, record, and manage that. You may have to refresh existing consents if this does not meet the high standard in the GDPR. I recommend that you look at the ICO guidance on consent, as this sets out very clearly on how to achieve the required standard. So this personal data audit will enable you to devise a suitable privacy policy or review an existing policy, and then you can continue to provide this to individuals at the time you collect their personal data. You should also ensure you can comply with the exercise of any individual rights, and be aware and make sure you can comply and report any data breach to the ICO or the individuals within the required timeframes. Finally, I recommend you go to the ICO website, undertake the self-assessment, and register if this is required and you've not already done so. As I said, that's going to be an annual requirement on you. Where to find guidance? Well, as I say, the ICO website has some really helpful information for you, and a lot of this is aimed at small organisations. It also operates a dedicated advice line to help small organisations prepare for the new data protection laws. The telephone number is there on the slide. As I say, I highly recommend you look at it, because whilst this talk has covered the main aspects, it does not cover everything in fine detail. Of course, if you're a member of the ISM, you can contact us here in the legal team and we will be able to help you. So I've now come to the end of my webinar. Thank you very much for listening. I have had quite a few questions in advance of the webinar, which I'm going to address now. And whilst I'm not taking live questions, if you are a member of the ISM, do feel free to contact us if you need any further information on these topics. So, I've had some questions, one of which is, as a singing teacher, I'm interested to know what exemptions or other special provisions will apply to educational records, exam results, competitions entered, etc. Also, do I have to make special provisions if this information was in the public domain previously? Well, there are no exemptions in these cases. There are exemptions in the Act, but they tend to apply for national security, crime detection, etc. So the rules will apply in the same way, and that is you should tell individuals how you're going to use their data in a privacy policy. Make sure that you have or that you satisfy one of the conditions for processing their data. And the next question is what records will be allowed to be kept about former clients? So for business purposes and also for analytical research purposes, the records are kept by this person. In principle, this could extend to such things as the reliability of a customer regarding payments, which could have implications at some point in the future. What records will it be necessary to keep, and shall we be allowed to keep under the new regulations that might be required for business purposes and/or any future legal official investigation should it be required? Well, the data protection rules don't tell you what data you can and can't keep. You've got to make an assessment of that. So you can keep records where you satisfy one of the lawful conditions and you comply with the data protection principles, and you also, where you do satisfy one of the conditions, make sure you've captured that in your privacy policy and notified that to individuals. So, for example, here, for analytical research purposes, you may be able to argue that you have legitimate interests. And the same goes regarding payment histories for customers. But you should ensure, as I say, in accordance with the rest of the data protection principles, that the records you keep are adequate, relevant, and not excessive. You don't keep them for longer than is necessary, so do consider your retention periods, and also set out the reasons you retain their information in your privacy policy. The next question is, how should such records be kept? Do they have to be kept by electronic means? Or if not, will they require physical access protection? Well, the Data Protection Act doesn't actually tell you how you should keep records. What it does tell you is if you keep them electronically, or if you keep them in a manual filing system which is organised by specific criteria, then the data protection rules will apply to you. The next question is, under the new regulations, what permissions are needed from current and future clients regarding any information I hold that relates to them? Will this permission need to be held in writing? Also, relating to the historical records of previous clients, will it be a requirement to obtain permission from these clients to hold that information? I have thousands of clients, former clients, and tracking them down may not be possible. So I think you need to consider, in line with data protection principle 1, that you process that data lawfully. And there are several conditions which you might be able to rely on, including performance of a contract, legitimate interests. Consent is not the only ground for holding personal data. So you may not need permission at all if you can rely on performance of a contract, for example. In relation to previous clients, I think you need to identify why you need to hold their information and then identify a legal basis accordingly. And then consider your retention periods, because you don't want to hold data for longer than necessary. So for former clients, you need to take a view on whether there are good reasons to hold on to that data or whether it should be securely deleted. Okay, I'm just going to go through one more question now, which is from another member of ours, and it is that she keeps addresses and phone numbers of band members. So, what are the implications of GDPR here? Well, personal data, it's personal data if it relates to living individuals, but it may not be personal data if it doesn't include the names and addresses of any individual. For example, if it just relates to a club or a society. Now, if you process that personal data, you've got to make a privacy policy available, and make sure again that one of the 6 or more lawful conditions for processing apply. So, for example, phone numbers of band members, it could be for the performance of a contract, or you may have a legitimate interest which relates to your business. Okay, well, thank you for attending today's webinar. I hope you found it helpful. And as I say, members, if you have any questions, do feel free to contact us. Thank you.